morning and welcome to this meeting on the Committee on the Revision of the Penal Code, which is now in session. I am Mike Romano, Committee Chair. We'll begin with a roll call of committee members in alphabetical order. Assemblymember Bryan cannot be joining us, so Judge Espinoza,
Present.
Professor Ochin,
Present.
Rummel,
Present.
and Senator Skinner is not here, but we expect her soon. Today's agenda will cover three different topics. We'll begin with research on the driving under the influence issues that we've been considering all year. Then we'll move to issues involving innocence and wrongful convictions. And third, we'll discuss a new issue involving sentence credits for people serving life sentences. We have 9 expert witnesses who will join us today. And of course, we'll take a few breaks along the way, including for lunch around noon. And as always, we'll close with public comment. Let me make a Bagley-Keene reminder. This is our third meeting under the changes to the Bagley-Keene Open Meeting Act that became effective this year. As required by law, members of the public can watch and participate in this meeting in the first floor conference room at 925 L Street in Sacramento. And thank you to Megan for being present at that location for us. And as a reminder to committee members, the law now requires that members of the committee be visibly appear on camera during the meeting unless there are technical difficulties. If you have any technical difficulties, please rejoin the meeting without video and we'll handle it from there. So Professor Ochin, if you could join us, that would be great. Our first presentation today is from our friend and colleague and frequent co-collaborator, Professor Steve Raphael from the Goldman School of Public Policy at UC Berkeley and California Policy Lab. Steve is going to present data to us about possible effects of changing California's blood alcohol content level in our DUI laws. We've been exploring this topic since March and wanted to know more information about the impact on road safety and possible racial implications of disparities in enforcement that might be caused by changing California's DUI law. Steve's presentation will address these concerns. We'll hear from Steve for 5 minutes, and then we'll have Q&A with him for a few more minutes after that. Good morning, Senator Skinner. So may the record reflect that Senator Skinner is with us now. Steve, it's good to see you again. Please take it away.
Okay, thank you. Can everyone see my screen?
Yes.
Okay, great. So thanks so much for having me. Today's presentation is more a review of what the research says on the effect of legal blood alcohol limits on public safety, and then some attempts to say something about the equity implications in terms of race and ethnic distributions of stops, traffic violations that are alcohol related. We can talk about the exact definition in a moment. And what the evidence says, right? So that was kind of my task, and that's what I set out to do here. So basically what I'm going to do is I'm going to focus on a few things, just give you a quick overview of the state of legal blood alcohol limits in the United States and elsewhere. What are some prominent bodies recommending? What the evidence says about the possible effectiveness of going from, say, a 0.08 limit to a 0.05 limit, and then review what we know about the likely impacts of this in terms of additional convictions and maybe racial and ethnic disparate impacts of lowering the law. So first things first, just to note the current state of the law in the United States. So every state, with the exception of Utah, has a BAC limit of 0.08. And basically what that means is that if you're stopped and you blow a test that gives a blood alcohol level of that or higher, then you're legal by definition. So there's no further evidentiary requirements. But you can still be convicted of DUI for having a blood alcohol limit below that level if you fail, say, a field sobriety test. Aside from that limit, there's also usually differential limits for people under 21. So in most or in every state, there's a restriction that people under 21 can have a BAC over 0.02. In California, that limit is 0.01. And then also in California, drivers on DUI probation have to obey a legal limit of 0.01. And then finally, Utah is the first and only state to reduce its BOC to 0.05. And that happened, I believe, in 2019. In terms of proposals to lower the legal limit to 0.05, there are a couple of key recommendations regarding this proposal. So the National Transportation Safety Board, the World Health Organization. The one that I'll focus just briefly on is the proposal or the recommendation by the National Academies of Sciences. So the National Academy of Sciences, basically one of the main products that they do is they assemble these expert consensus studies where they'll get a panel of a dozen or so folks who will all research the topic. They review the scientific evidence, and then they either come to a consensus or they don't. If they don't come to a consensus, then there might be minority recommendations, there might be dissents, and so on and so forth. They issued a report in 2016, Getting to Zero, and they reached consensus, and one of their consensus recommendations was lowering BAC to 0.05 would improve public safety. And that's based on an expert panel review of the existing evidence. In terms of where in the world BOC limits of 0.05 exist, so it's common throughout Latin America, Asia, Eastern Mediterranean, some African countries, and almost all of Europe, with the exception of Malta and the UK, and most of the UK. I think Scotland has 0.05. So evidence in terms of public safety, my reading of this literature is that basically you have three different sets of studies that are commonly cited to evaluate the effects of a BOC. There's laboratory research that basically increases people's blood alcohol levels to various ranges, say 0.02, 0.03, 0.04, and then tests their psychomotor skills, and in particular the psychomotor skills needed for driving. So the NTSB summarizes that that there's evidence that at 0.02 there's decline in visual function. At 0.05, there's reduced coordination, reduced ability to steer, and so on and so forth. And based on this evidence, the NTSB argues that having a BAC between 0.05 to 0.08, it for many people is actually not. You already see an erosion in safety. There's also a second body of research that sometimes referred to case control studies. It's actually based on a relatively small number of locations. But basically what they do is they compare the blood alcohol levels of people that are involved in crashes. And then they go back a week later at the same time and place, stop somebody at random who has not been in a crash and measure their blood alcohol level. And from that, they can estimate the relative risk of being in an auto crash with a BOC, a BAC of 0.01, 0.02, 0.03, and so on and so forth. And if I have data on this that we can look at, but the summary is basically that between 0.05 and 0.08, you tend to see an elevation in the relative risk of a crash. Now, it increases exponentially beyond that, and it's much higher, but there is some evidence that at relatively low BACs and below the current legal limit, you find an elevated risk of a crash. The one caveat there is that there's a strong interaction effect with age. So people under 21, that's where you really see a fairly large increase at that level. And currently people under 21 are already subjected to a lower BAC limit than people over 21. And people over 21, it's less so. But that's what that evidence shows. And then the third body of research is a series of evaluation studies that basically just simply ask the question, okay, Utah lowered its BAC, what happened? Or in Canada, in these provinces, they lowered the BAC administratively anyway, if not in the criminal code, from 0.08 to 0.05. Do we see subsequent reductions in crashes and fatalities? Or another, sort of approach to this would be to look at the move from 0.1 to 0.08, or even introducing the 0.1 limit in the United States and exploiting the differences in timing across states, or in Europe, the differences in timing across country, to try to see if you see co-occurring changes in crashes that suggest that the BAC limits reduce things. For the most part, this evidence does suggest that BAC limits, as you tighten them, that they lower crashes, they lower fatalities. It's probably the case, given the results from the case control studies, that as we make them lower and lower, that the benefit in terms of reduced crashes is diminishing, because the there's this exponential increase in relative crash risk when we get into higher and higher BAC levels. There's one study of Utah, and my reading of it is frankly that it's inconclusive, largely because there's a law that goes into effect in 2019. The researchers study a change in crashes between 2016 and 2019. And there are other things reported in the report that are also happening in Utah. In particular, they note a large increase in funding for state highway patrol DUI enforcement. But nonetheless, I would, my reading, I mean, it's never the case that all research agrees and finds the same thing, but it does look like the weight of the evidence is that lower BACs, the move from 0.10 to 0.08, and then some of the careful studies in Canada and Europe on 0.08 to 0.05 suggest that there's a reduction in crashes. And so my general takeaway from all of this would be that you'd probably have a reduction in crash volume if we had a lower BAC and probably fewer fatalities. It's also worth just noting really quick, what are the mechanisms? So there's a lot that's hypothesized about what happens when you lower BAC. One is simply that you catch more people and then you incapacitate them with an IID, or it's a shock and they change their behavior. Another is that as the legal limit is lower, everybody becomes more conscious, even somebody who would normally drink to the point where they're 0.15, 0.2 and drive, maybe they'll drink a little less, and that can happen through the entire distribution of drinking behavior. There's less conclusive information on whether there's general deterrence effects, whether there's specific deterrence, incapacitation, and so on and so forth. This is kind of open questions. Okay. Now, I tried to do a few tabulations of what we would expect to happen in terms of additional convictions. So what you can observe in for example, the Department of Motor Vehicles DUI reports, you can see the blood alcohol concentration of people who are convicted for DUIs and wet recklesses. But you can't see the blood alcohol concentrations for people that weren't convicted. So if somebody stopped and blows 0.06 and then they're given a warning and sent home, you can't observe that. So it's hard to just move the threshold down and sort of aggregate and ask how many additional convictions we'd get. But I did do a couple of back of the envelope calculations and some projections based on methods we can talk about in a minute, and if there's interest. And my best guess is that, in 2019, there were about 82,000 DUI and wet reckless convictions. If there was no behavioral response and we lowered the limit to 0.05, you'd probably net 91,000 convictions, so an additional 9,000 or so people. And that seems to accord also when you look at the blood alcohol contents of drivers who are involved in fatal crashes. So there's about 13,740 people who are involved in fatal crashes that have a BAC of 0.08 or higher. When you look at people who are in that 0.05 to 0.079 range, there's about 1,012 drivers that fall in that range. And so kind of, if you just compare that 1,012 relative to the 13,740, it's similar to the 9,000 relative to the 82,000. So it suggests that there certainly are crashes of people that fall in that range. Most people who are stopped and convicted for a DUI have BACs that are well above 0.08, but there is a drop at the distribution there that we can look at if there's interest.
Steve, let me just ask real quick. Can you go back?
Sure.
So just to make sure, 2019, there were 13 or almost 14,000 people with BAC or higher in a fatal car crash. Is that correct? Am I reading that correctly?
That's right. That's
And
right.
that there were
Yeah,
additional about 1,000 who were between 0.05 and 0.08.
that's right. And these could either be the people who died well, I think
Yep,
it's
yep,
the numbers like 65% of the drivers that themselves who die, but this is the driver involved that is alcohol involved. That's right. Okay, so in terms of race, ethnicity disparities in DUI arrests, so there are a couple of different data sources that we can look at specifically for California here. Number one, there's information available on the race ethnicity of drivers that are arrested for and convicted of DUI. That tends to show some race disparities. So I think it's on the order of 12% of arrests and convictions are of African Americans, and almost a little over half are Hispanic Latino, and that the California population is about 6% Black, and the Latino population is 42%, 43%. So there's overrepresentation among those groups. Um, One of the things we can do, and what I did is I took the RIPA data, which is stops for 2021, and just looked at everybody stopped for 21,252 and 21,253. I'm going to just look really quick. I'm going to
No,
cheat
Steve,
because
Steve, let's move on.
Okay, all right. And basically what you tend to see is that that the racial distribution of stops match the racial distribution of convictions. There's greater disproportionality for non-DUI stops than for DUI stops. And when you look at what happens in those DUI stops, basically the same thing is happening for people regardless of their race, ethnicity. About 80% are arrested, 9% are receiving a citation, and then the rest are receiving a warning. And then the final sort of comparison I did was just from the DUMIS, you can look at the race distribution of drivers that are involved in alcohol-involved fatal crashes. And so these are drivers that are impaired in the crash. And that distribution looks pretty similar to the stops, looks pretty similar to the arrests and convictions. So if we think of these things as a benchmark, there may be slight overrepresentation, but the stop data suggests that people are being treated the same irrespective of race, conditional on being stopped, and the race distribution of people that are arrested, convicted, stopped matches pretty close to the race distribution of people involved in fatal crashes.
So
Uh,
just to understand that the upshot here is what you're saying is that in general, yes, people of color, especially black and brown people, are stopped more often on all traffic stops, but for DUI stops, not necessarily. It seems like it's not, and you're using the as a benchmark the people who are involved in fatalities
that's
and
right.
making sure. Okay, that makes
That's
sense.
right.
All right.
That's right.
I just want to keep us on schedule, so I just
Yeah.
want to.
And that's it. Those are my takeaways. And if you want
Oh,
to
you had
look
all
at
those other
specific
charts
things,
too.
I can find. No, no, I was going to focus on the five, and if you want to look at specifics, I'll go to them.
Okay, okay.
Before you move
Um,
on, I have a quick question.
yeah, of
Mhm.
course.
So I understand the point that you were making, Professor Raphael, about the sort of uh, roughly equivalent treatment of different racial groups, particularly Black and Latino drivers who are stopped for DUI versus um, their white counterparts. But
Mhm.
you also mentioned earlier that at a point oh 0.08 standard, the behavioral effects are greater than they would be at a point oh 0.05.
Mhm.
So this aligns with studies that demonstrate that racial disparities in stops and stop and frisk, for example, the treatment of individuals who are stopped goes down, like they're more equalized when the police have greater evidence of a violation of a crime, right? So higher rates when there's more evidence of, say, a probable cause. Um,
Mhm.
so that seems to me to be in alignment with what you're arguing, right? So there's more behavioral effects at a point zero 0.08, and so people are stopped roughly equivalent based on these sort of this more expressive behavior that comes as a result of being more intoxicated. You mentioned at point zero 0.05 that behavioral effects are reduced, and so there would be more discretion, I imagine, when police would choose to stop using the justification of DUI. I'm wondering, is that a reasonable inference to come to, or do you think that if the BAC level came down, the you would see equivalent rates in terms of stops and the treatment of
Yeah.
drivers irrespective of race?
Yeah, that's a good question. And I mean, maybe to answer that, we can just look at just a few tabs, and I promise I won't go too nuts, right? So, um, this is that relative risk ratio that you see this cited in a lot of these studies, which is the relative, it starts at one, and it's the relative risk of being in a crash for different BAC levels relative to having a BAC level of zero. It starts at one, and then it grows to 150 when people are 2.5. And this is the range we're talking about here from 0.05 to 0.08. So if we zero in there, you can kind of see that it's, going up from say, 1.3 to a little over 2 for the average driver, and then it's higher for young drivers, right? So in this range, if, whatever externalizing effect is associated with this elevated risk, whether a police officer picks up on it, they're probably more likely to pick up on it for people that are out here, right, at 0.2, 0.25. And indeed, when you look at the BAC distribution of people that are convicted, right, what you're seeing is that the typical person that's being stopped, arrested, convicted has a BAC level, which is 0.15, right? So they're pretty inebriated. So, in this range, presumably the signs of being impaired when you're driving are going to be more subtle, right? And they're going to be less really driving erratically, sort of swerving in and out of lanes, speeding, stopping, or whatever the signals are. And it might be something that could signal impairment or not signal impairment. And to that sense, maybe it's a little bit more tea leaf reading in this range than it would be somebody who's up here, right? And to the extent that that's true, then to some degree, it's probably more of a judgment call than, probable cause. Somebody's driving at 0.18, 0.2, and, who knows, right? So I think that it's, it's entirely possible that these stops would be based on external behavior that is sort of less probative than stops that were occurring at higher BACs.
Let me try to understand Professor Ochen's question and your answer, Steve, to make sure I get it right. Professor Ochen, I think that you're saying that people with the lower BAC levels, their signs of being intoxicated will be less obvious and therefore more prone to biased arrest. Is that your concern?
Yeah, so basically, when there's less evidence that there's a violation, that they're driving above the legal limit, right? Their behaviors are more subtle, and so the things that might alert the police to them or might drive the police to stop them might not just be their behavior. It might be other forms of. It might be driven by racial bias, in addition to whatever the subtle cues are. So that's what I'm suggesting. That's consistent with other studies that demonstrate when there's higher rates of discretion, that's when you see higher rates of bias, right? That's true in the death penalty. That's true in the RIPA data that's released every year. So that's where my question is coming from.
And Steve, did you answer that specific question, or does your
Yes, and I think sort of in my kind of nerdy way of doing it, it's I would say that if you're a 0.15 and you're driving in a manner that makes you 25 times more likely to get into a crash than if you're 0, you're probably sending a lot of signals that you're inebriated.
Yes, we get that. I guess the
Yeah.
question is, do we have any do we have any reason to believe, based on the data that we have, one way or another, that the people who are between 0.05 and 0.08, that there's a racial disparate impact in those cases?
Well, it's hard to know because we don't have access to race-specific distributions of blood alcohol levels. And we can't observe the BAC levels of people that aren't convicted, right? And so to really answer that question, and in some ways it's a different question than Professor Oken's question. But if we just simply said, okay, everybody, if we get stopped and we have everybody 0.05 that's convicted, now it's everybody 0.08, then it's a mechanical question of well, who is in that 0.05 to 0.08 range and how does that compare by race, ethnicity? I think the professor's question is a little different. It's more, well, if we now have this lower legal limit and where we have greater discretion to make stops because we think people are among that lower legal limit, then you're probably looking for more subtle rather than very, sort of obvious cues of an impaired driver. And that's sort of the charge that you're handing to law enforcement in the state.
Right. And so my question is, when you have less evidence of impairment and there's more discretion as to who to stop, would that increase the racial disparities that we see in not only stops, but also in terms of the treatment, right? So the current standard of impairment, what Professor Raphael suggested is that we don't see disparities, right? There might be slight disparities in terms of who stopped, but in terms of how folks are treated when they're stopped, right? Are they subject to a field sobriety test and so on? That's consistent, and that the rates of conviction are consistent. My concern is that when there's less evidence of obvious impairment, that the stops will be driven more by other factors, including race, which would then exacerbate or increase racial disparities in the stops and also in the treatment of drivers if there's less evidence of impairment, right? So an officer stopping a black or Latino driver might subject that person to more inquiry than a white driver who is similarly impaired but not showing as obvious a sign of impairment is basically my question and concern.
Yes, and that I think that's possible. The one thing we can say from RIPA data is that when you look at people stopped, and this is where I was the 21, 152, 21, 153, those stops, when we compare by race and ethnicity, if it was the case that people were being stopped under the pretense it's a drunk driving stop and they weren't actually inebriated, you would see lower arrests or less likely to cite. And you kind of see uh, relatively comparable rates at the current level of 0.08. Now, from 0.08 to 0.05, who knows, right? That you're raising a theoretically plausible scenario.
Stephen, and we don't have a ton of time left, so I know you're not a huge fan of the Utah study, but maybe the Canadian studies. Do any of those studies discuss racial impact of changing the BAC levels? And I guess when we changed our BAC level from 1 to 0.08, did that change from 0.1 to 0.0? Were there any
Yeah, so
racial
I haven't, as far as I know, I'm not aware of research. First of all, the Canadian research, there are a couple of papers, one looking at when they lower kind of locally determined administrative sanctions at 0.05 versus 0.08, and they appear to find effects on public safety. Really no attention to race or ethnicity or socioeconomic status or differential impact. And as far as I know, I don't see a lot of research studying the effect of going from 0.01 to 0.08 or 2.01 or 2.1, excuse me, on racial disparity and stops. It doesn't appear to be an area that's been a focus of this research. There is one study by Garen Wintermute at UC Davis and his colleagues that compare people who purchased a firearm and there are some risk factors that
so we don't want to get too down. Right.
Okay.
So you're saying that there's no, I'm shocked. There's no date. First of all, I'm shocked in part because I think that we learned that DUI is the most common arrest, at least in California. So extraordinarily common crime.
Yeah.
And did the whole country move from 0.1 to 0.08?
In the US, yes, at different times.
Yes. And
Yeah.
there's no studies on the racial impact of that change?
To the best of my knowledge, yeah.
Wow. Tommy, is that your understanding as well?
Yeah, it was done a while ago, and I suspect there just wasn't the data kept on the way we keep now. RIPA is a relatively new, groundbreaking thing that California did. So when a change happened, like in the late '80s, early '90s, yeah, it's too bad, but I'm not shocked by that.
All right.
But I think while I called on Professor, Steve, I think the thing that strikes me about the 0.05 versus 0.08, the sort of graph and the relative risk, is that 0.08 is higher, but at least on the scale that we're looking at, it's not significantly higher. So the difference between someone driving with a 0.05 and a 0.08 may be pretty subtle. It's not as if we're going and sweeping in a lot more behavior that's actually looks safe to us. It's actually a pretty relatively minor difference, while 0.08 is higher, and that's why we would see some maybe impacts on road safety.
Yeah. So basically, here's double the accident risk, and you're hitting that at about 0.07, right? And so somebody in that range is double risk. I think though the research in this, they're both studies using the same data. When you break that out by age, for people that are over 21, by the time you're at 0.08, you're almost double the crash risk, but older drivers are generally more safe. And a lot of the kind of really risky driving in this range is among young people, 21, under 21, right? Where you see 4 times the risk of a crash, you know, at 0.07 rather than 2.
And
And
their
this group is
BAC is
already
already
subject, yeah, to
right.
0.01 in California. Yeah.
And I think the other thing I think about too is, you know, when a officer is evaluating whether they have reasonable suspicion to pull someone over, they're not necessarily, I guess, saying I think their BAC is a certain level. It's just based on the driving behavior. And I think when we looked at these issues, I don't know, 2 years ago or whatever, there's maximum discretion already to sort of pull people over for things unrelated to DUI. So I think this would give a little bit more discretion, but it's sort of I don't know, a drop in the discretion bucket that already exists in a way.
I have a question about safety. Um, I know that you said that there's about 9% of fatal 1,000 fatalities in 2019 were in this range that we're talking about, 0.05 to 0.08. And that you expected about the same percentage, which is about a 9%, I believe, increase in the amount of arrests. Is it fair to extrapolate that you would also expect to see a 9% drop in accidents and or fatalities by moving from, I know that the Utah study, which again, I think that you're not a fan of, found a 20%
Yeah.
reduction, was pretty eye-opening to me. You know, I thought that seemed pretty significant and a pretty important way to improve public safety. Can you put a number on, again, best guess, back of the envelope?
Yeah, I think that's very hard because just because you make driving between 0.05 and 0.08 illegal doesn't necessarily mean you would eliminate those fatalities, right? Because we have plenty of fatalities above 0.15.
No, sure, of
And
course, but
I think, you know, the question becomes what are the mechanisms that would lead to the reduction? So is it that you catch more people who are in need of
right.
an intervention? Story one. The other story is the whole world now knows it's 0.05 and it's just way more careful, right? And if that general turn effect and the Canadian researchers claim to see evidence of that by changes in the BOC before and after before
Do
and
they have a
after.
number that that's what I'm trying to get at. So the Utah study, I think, said it found a 20% reduction in
Yeah,
accidents, which is a lot.
which is substantial. Yes.
Right.
Yeah.
Did the Canadian studies put a number on it?
Uh, I don't recall. I don't
All right.
recall, but they did find significant
But you
decline.
seem to
Yeah.
be, you used a lot of terms like suggest and seems and seemed a lot less sanguine about.
Well, I would say that the research on, you know, the panel data research going from 0.1 to 0.08 is pretty solid, right? Um, the Utah study and my main kind of concern about the Utah study is the researchers are comparing a change from 2016, 2019. The law goes into effect in 2019. A lot of the changes happening in 17 and 18. And so it just seems we know that the law was passed earlier, but why everybody would change their behavior so much before it's actually into effect kind of requires explanation or exploration. And I think the other issue there is they have a big increase in activity by their state highway patrols, which they document in the paper, which is not only in terms of funding, but DUI arrests that they're making. And there's very solid evidence that enforcement efforts by state highways actually reduce traffic fatalities. So that you know for that reason, it's you know when I'm reading through that, it seems well there's plausible alternative explanation for what we see in Utah. And then also I think Utah is also when you look at the distribution of just the number of fatalities per 100,000, it's way at the bottom of all of 50 states. Drinking behavior is clearly not the same, and even alcohol availability, I think, in Utah and in other areas. And so, I don't know if the 19% is the correct number, and then B, whether it generalizes California is another issue.
Do other Professor Ochin, did you get your questions answered? Do other members have any questions for Professor Raphael? All right. Thank you, Steve.
Okay.
This is super helpful. I think we're going to continue to mull on this. My just to summarize where I think the committee is, I don't think that we've made any decisions yet, is I think that we're persuaded to some degree that reducing the BAC level from 0.08 to 0.05, or let me just speak for myself, will have some positive public safety impact. Measure of that might be harder to, but as with all laws, we are very concerned with any laws that exacerbate racial disparities and give even more, add to the problems that we see, you know, throughout the criminal legal system. And we certainly don't want to contribute to that inadvertently. And I guess the question was, and you know, I still think that we need to think about it some more. And Steve, if you could continue to think about it, and if you come across anything, please send it, you know, our way. Particularly on A, the public safety impact to the extent that we can measure it, and B, again, this question of racial disparities by lowering the limit, would that just give police more reason to pull over and exercise their power in a racist manner? So that's what we're struggling with now, or that's what I'm struggling with. Does anybody else want to add 2 cents, or should we move on? Yes, Senator Skinner.
Uh, so I guess the only way that actually you achieve, if we lower the limit, the only way to increase the result being less accidents and such is if there's real enforcement. And the we already know that our local law enforcement are very stretched. They're not, there's much that they're not enforcing right now. Whether CHP is really stretched, I'm not sure. But I think the net result, given the circumstance of our law enforcement resources at the moment, is that we would have, we would increase the racial disparity just because of the nature of where law enforcement is even concentrated in terms of their enforcement or in general. So I think it's hard to look at this from purely the lens of if there's less inebriated people on driving, or it's not just inebriation, there's also, as we know, impaired driving from other substances.
Right.
Yes, it would be safer, but how is that achieved? Purely lowering the limit doesn't necessarily have, I mean, I haven't seen, maybe there's some research that shows that lowering the limit, in fact, causes people just to be to do more of calling the ride share, or, you know, not getting behind the wheel. But I don't know if there's a complete correlation there.
Well, my hunch, and again, I don't think there's a ton of research on this, and Steve even said that there wasn't, about the deterrent effect, is that the main effect wouldn't be actually through enforcement, it would be through deterrent to the extent that there's a public safety benefit. Of course, that doesn't address the racial disparate enforcement that we're talking about. The only other thing that I wanted to add is our conversation when we originally spoke about this, I believe in March, also had the idea of pairing the a proposal to reduce the BAC to 0.05, which I think would be significant news and have more deterrent effect than a typical criminal law that's passed. I mean, I think that it would be front page news if California reduced its BAC limit to 0.05, and first in the country behind, or second in the country behind Utah. But the proposal that we had discussed, and if Tommy, correct me if I'm wrong, that this is actually in the staff memo, is to pair it with a mandatory diversion for first-time offenders, so that the consequences of a conviction or arrest would be lower. Is that correct, Tom?
Yes, that's how we've thought about it. And you know, I can't remember the exact number, but it's a vast majority of convictions are for first DUIs. So it would lowering the BAC would widen the net in a sense, but the mandatory diversion would significantly shrink the court side of it and the consequence side of it in some respects.
Professor Ochin, did you have a question or a comment?
Yeah, so I just wanted to add two things. One is I wanted to put a point on what I'm concerned about. One is that I'm concerned, obviously, about the racial disparities in the stop, but I'm also concerned about reducing interactions, particularly interactions that can escalate between police and people of color, right? And DUI stops are the kinds of stops that can lead to significant intrusions into, ordering people out of cars, right? That kind of thing is where things escalate and people can be harmed. And so my concern isn't just with the stops or arrests or whether people will be diverted, it's whether there will be harmful or violent interactions between law enforcement during the course of these stops, because the officers may need to do more investigation to determine if the person is actually impaired or in violate at a rate of 0.05 because their behavior may not be as obvious. So that's one of the concerns that I have. The other question that I had is just I'm not clear on how drivers under the age of 21 are regulated on the road. Is there a different standard for them, given that one, they can't drink at all, and two, they shouldn't be drinking and driving, and three, they're the drivers that are at highest risk of are getting in accidents and fatalities based on Professor Raphael's the data that Professor Raphael shared with us. So I just wasn't clear if there was a different approach for drivers under the age of 21 when it comes to impairment.
Yes, it's 0.1, correct? 0.01, I'm sorry.
0.01, yeah.
Steve, and then I'll go to Professor Rommel. Is there any way that we can use that data, the move, to like look at 20-year-olds or 19-year-olds or people on the cusp to see if there's racially disparate?
It's a good question. Yeah, that's a good question. I don't know. I mean, so you would, there are these abstracts of judgment that the DMI or the DMV uses to calculate those distributions. And so you could look at people under 21 and see who's in that range. Whether that applies to older people is a different story entirely. One thing I just would add about the general deterrence effects, in some ways, the sanction structure for a DUI is one that is, you're arrested within 30 days, you have an APS suspension, and you can avoid it by getting an IID installed. Like it's designed to really kind of make the consequence of getting a DUI very salient and very quick, which, a wide body of research suggests is the way to create a general deterrent rather than having something that happens way down the line. So I do think that there's reason to believe that there's general deterrence associated with the sanction structure we have. And if it went to 0.05, probably people would think, well, maybe I should call an Uber or drink a little less. And even if they don't drink less and they call an Uber, I think from a policy perspective, that would be a win too, right? So then they're not driving when they probably shouldn't be. So yeah, I don't know. And it is the research is a little thin in this range because there's only one state that's tried it and it's not a exactly representative state.
Great. I understood. Thank you. Professor Rommel.
Quickly, I want to echo Professor Ocean's concerns, and I'm glad we're going to spend some time trying to get more information on that point. But my question was just related to the last thing that Tom Noswitz said. The mandatory diversion is that related only to the people who are between 0.05 and 0.08, or would that be a change for everyone who's arrested for DUI, no matter what the blood alcohol content was?
Well, we think of it as for everyone, because in fact, most
Okay.
people convicted of DUI have a 0.1 something BAC.
Okay.
So
Thanks.
for it to have an impact, yeah.
Judge Espinoza or anybody else have any last comments or questions for Senator Skinner? Okie doke. Thank you, Professor Raphael.
Okay,
super
thank you,
illuminating
everyone.
as always. No good deed goes unpunished. We will see you again soon, I'm sure. All right, thank you. Now we're going to move to our next topic, which is the question and problem and issues around innocence and wrongful convictions. And before we get started, I want to say a few words. First, more than 250 people have been convicted of a crime in California and later found to be actually innocent. And this number is obviously a large undercount. These cases present the most profound injustice in our system, and they present a serious public safety issues because if the wrong person has been convicted, then the person who actually committed the crime remains free in cases. California has taken significant steps in recent years to allow for people to prove their innocence in court and receive compensation from the state for time spent unjustly incarcerated. But as we'll hear today, the current state of the penal code on these issues is complex and confusing. I believe this law in this area would benefit greatly from recommendations from the committee to improve consistency and fairness. One final point. While ensuring that innocent people have strong remedies for relief, it's extremely important. I want to make clear that our criminal legal system has other epic problems, including unnecessary incarceration that serves little public safety purpose, and other racial disparities that the committee has been addressing for the last 4.5 years. While innocence is obviously important, these other pressing issues also must be fixed, and I think I speak for the entire committee on that point. With that said, we'd like to get started. We'll begin with panel discussions. I want to thank all of our panelists for sharing their insights with us today. As is our custom, we have a strict 5 minutes policy for opening remarks, and we reserve the rest of our time for Q&A. Panelists, please know that if you've given us a written submission, we have read it. So in your opening remarks, please quickly hit the high points so we can move on to our conversation, which is the most important and productive part of our meeting. Our panel today comprises of people who have been found innocent after being convicted in a crime. People who have been found innocent after being convicted of a crime. Our panelists are John Eldon, who's the founder and executive director of After Innocence, and James Mink, who's the policy lead at After Innocence, and Obi, or is that pronounced her name correctly? And Obi Anthony, who's the founder and executive director of Exonerated Nation. Mr. Eldon and Mr. Mink, you have 5 minutes together. Please take it away.
Okay. Thank you to the committee and the staff for this opportunity to speak about how California responds to wrongful incarceration. My name is John Eldon. I'm an attorney and the founder and executive director of After Innocence. We're an Oakland-based nonprofit that focuses exclusively on providing post-release assistance to people who were imprisoned for years and in many instances decades for crimes that they did not in fact commit. For the last 10 years, I spent nearly every day working one-on-one with many hundreds of exonerees across the country and 81 exonerees so far in California as they rebuild their lives. This work is primarily focused on ensuring that California exonerees have access to the health care they're eligible for. We provide case management support to help them make good use of that health care, scheduling doctor's appointments, helping maintain coverage, and with a specific focus on diagnosis and treatment for mental health issues. For dozens of California exonerees, this work has also meant pro bono legal services that we've coordinated, financial counseling to increase their economic self-sufficiency and well-being, and more than $100,000 in donated dental care through our annual dental program. Our team now serves California exonerees under the Adult Reentry Grant, which has enabled us to dramatically improve the overall post-release services available to California exonerees. And the vast majority of the services we provide, our clients would not have received from any other source. And this starts as soon as we reach the exoneree. If it's somebody newly released, then immediately upon release. And we've also gone backwards to reach California's exonerees, people who've been exonerated from California prisons in past years and decades. In doing this work with hundreds of clients, we have seen on the ground how statutes across the country do and do not deliver compensation and services to this uniquely deserving population. We draw from this deep experience in our work, and as we look and comment and make recommendations on compensation and post-release services bills, we've drafted, testified in support of, and provided data on bills in 12 states, including California, and are pleased to do so today. I'll turn it over now to my colleague, James Mink, to give an overview of our recommendations. Thank you.
Okay. So I want to just give an overview on three main issues: harmonizing the compensation statutes with a thorough redraft, consolidating fact-finding in the courts, and bringing California's wrongful conviction compensation approach in line with best practices in other jurisdictions. First, the redraft. California's wrongful conviction compensation statutes have been repeatedly amended in a patchwork fashion, resulting in an approach that now uses 4 different standards for innocence, treats factual findings on habeas different from those on direct appeal, and has 2 separate but unequal paths to obtaining a finding of factual innocence. To address these issues rather than further piecemeal modification, we recommend that the statutes be thoroughly redrafted. Second issue, fact-finding by the courts. When California enacted its compensation statute, determinations of innocence for purposes of compensation were originally required to be made by the Victim Compensation Board, then known as the Board of Claims, because it was the entity that handled all claims against the state. So there was no option for having a court determine innocence. VCB no longer handles tort claims against the state, and amendments in recent years have allowed courts to make the innocence determinations for comp. And this route through the courts has been since then used by nearly all claimants. No other state uses 2 different fact-finding bodies for innocence determinations, and the 2 systems are increasingly diverging, with the VCB route becoming more restrictive in several respects than the procedures in court. VCB itself has expressed reluctance to have its findings even considered as innocence findings or treated similar to court findings. For these reasons, we believe the committee should recommend having all factual innocence determinations decided by a court, which is how it's done in 27 of the 39 jurisdictions with comp statutes. Finally, restoring California's status as a leader in wrongful conviction compensation. California and Wisconsin were the first 2 states with comp statutes over 100 years ago in 1913. But over the past 15 years, California's fallen behind other states in terms of exoneree compensation. For example, Idaho and other states provide additional comp for time wrongfully spent on death row, parole, or the sex offender registry, but California doesn't. One other example, 20 other jurisdictions provide separate awards of attorney's fees incurred in proving innocence or obtaining release, but not California. We believe the committee should recommend that at a minimum, California should meet or exceed the current state of the art for exoneree compensation in other jurisdictions across the country. Thank you.
Oh, you guys were exactly on 5 minutes, 8+ to both of you. Good to see you again, John. Mr. Anthony.
Yes, good morning. Good morning. Good morning to everyone. Good morning to the committee. Thank you for having me. My name is Obi Anthony. I am the founding director of Exonerated Nation, and I'm also an exoneree of the state of California. My release happened back in 2011. And I've been home and doing the work with Exonerated Nation since then. There's a law in the state of California in my name called Obi's Law. Our organization, Exonerated Nation, has been primarily focused on getting services, putting services in place for exonerees. One of being AB 1050, which gave exonerated individuals gave money, also automatic enrollment into Medi-Cal, Medicaid, also expungement all the way to the Department of Justice and the removal from individuals off of the sex registry that was also wrongfully convicted. Also, again, staying focused on services. Exonerated Nation was successful with 2 other bills in AB 701 and AB 703. 701 giving an exonerated population housing assistance for up to 4 years, and AB 703, which is also gave exonerated individuals, community free tuition from community college all the way to the university level. One of our main focuses at Exonerated Nation is not only that, but also the back end of it, for the services are concerned, things what we need when we come home, some of the things in which I did not have when I came home. And also establishing laws, in other words, to capture us when we do come home, similar to that which of individuals are coming on probation and parole. So we really focused on the services, and we yield our community to the innocent projects in their pursuit of compensation bills and things that they do. But we've been primarily focused on the services aspect. And also have one of my board members who's also is the lobbyist and works with Exonerated Nation in Ignacio Hernandez, and I yield over 2 minutes to him. So this is the California Penal Code.
Oh, the revision penal code. I got it. I could say, good afternoon. I think it's just about noon. Hold on, we're gonna shut this door over here. Can you all hear me?
Yes.
Okay, great. So sorry about that. I didn't know I was getting pulled in here. So I'm Ignacio Hernandez. I'm based here in Sacramento. I am a contract lobbyist. I have my own lobbying firm, and I do work in the criminal justice space quite a bit. Represent the California Attorneys for Criminal Justice. So I'm sure some of our reps have helped out there. And I've been in the past, criminal defense attorney. I think, I see a couple familiar faces now, but I've worked in this policy space for quite a while. And I also sit on the board of Exonerated Nation since it was founded with Obi. I met Obi when he was came up to Sacramento to work on some legislation on trying to hold prosecutors accountable. And so he helped kind of lobby on one of the bills. So where do you want me to cover?
Oh, that was good.
So that's who I am. So hey,
Great.
there's Mike. I haven't seen you for a long time.
All right. So good to see everybody. Thank you all for joining us. I guess Mr. Mink, you alluded to, and I don't think it's any surprise, and especially if you read our memo, the number of different standards for establishing innocence is pretty extraordinary, and it's almost impossible to say out loud or to present. You have to almost look at it on paper. One of our proposals is to create a consistent standard of what innocence means. And I know that sounds easy. It's to the layperson walking on the street, that sounds like easier said than done. Well, no, it sounds pretty easy, but it's actually easier said than done. And I guess what I'm curious about you guys, if you think that the right standard is a reasonable probability that a different outcome would be different in light of new evidence. A reasonable probability of a different outcome. Is that the standard that you guys?
Mike, if I can jump in, I think this is part of the complexity is I think you're talking more about the standards to get a conviction vacated in habeas corpus, and what James and John are talking about is sort of a separate.
So James and John, you guys are mostly talking about compensation.
Exactly.
Okay.
Exclusively compensation and services.
So let's stop there. So what is the standard that you guys believe that the standard should be for compensation? Let's start with that.
So the standard is sort of a tweak of one that appears in the 4900 series, and it's that basically proof by a preponderance that the crime the person was convicted of either was not committed at all or was not committed by the petitioner.
And proof by a preponderance of evidence that the crime was not committed by the petitioner.
Right.
And what is
That's
California?
Right. We should specify that we're talking about that as a gateway to compensation. There should be a different standard immediately upon release if there is a gap between release and the application and determination of compensation. So it's a bit complicated, but that standard that James just mentioned is the one we would propose and is consistent with the best practices around the country.
So I missed the nuance that you were talking about, John. So
he's making a reference, I think, to the statute that Mr. Anthony was talking about that provides some immediate compensation, housing, things like that upon release. That one has its own set of standards. There's one of the standards that's in there that's sort of similar to ours that we would want to sort of align with that, but otherwise.
We're talking about, so let's just start with the basic ordinary compensation. I understand that there's need for immediate assistance. Believe me, I get that. But for the bulk of the innocence compensation claims issue, what is California's current standard?
California currently has 4 slightly different standards, and as you mentioned, it's kind of hard to do them out loud without thinking about it, but without having it in writing. But we've got that, I believe, in our memo, and it may also be in the staff memo. One of the standards is similar to the one that we're proposing in that it focuses on proof that the petitioner, the crime at issue either was not committed or was not committed by the petitioner. Our small change to that would be, I think it focuses on the crime charged. In practice, it's always interpreted as applying to the crime they were convicted of. And so we think it makes sense to just say convicted rather than charged. But so that's a standard that appears in one place in the 4900 series and also appears in section 1485.55 in one of its subsections. The other existing standards appear in other subsections of those different parts.
And I understand that some of the other recommendations that you guys have are compensating for time on wrongfully on probation, wrongfully on death row, wrongfully on the sex offender registry list. I think that you guys also endorse making sure that the compensation amount is adjusted for inflation.
Right.
All right. And that determination, that all we need is a determination by court to have the victim compensation board involved is unnecessary.
In the innocence determination, the victim compensation board does a number of things that sort of
No, right,
yeah.
right, for this purpose.
Right.
Professor Rummel?
Quick question, just for the benefit of the committee's consideration, can you give us a quick overview of what the process of meeting one of these standards would be in front of the Victims' Compensation Board? Is it a paper process? Is it a mini trial? What does it sort of look like?
So it's funny that you frame it as a quick thing, and part of the problem is when we initially at staff's request tried to put together sort of a flow chart of the ways you get to compensation, it ended up being this sort of gnarly flow chart with a bunch of different branches because there are so many sort of different ways that have the different standards. As a generalization, I can say there is always a fact determination by someone, or rather there is the issue is always essentially, was there a crime committed? The burden gets allocated differently in different cases, but there's always a fact finder that's assigned to determine that. And there are some circumstances in which if the district attorney or the attorney general doesn't oppose, then there wouldn't be, a contested hearing, but they would be essentially stipulating that the burden has been met in that scenario. But so it's fact finding, it's potentially adversarial. In some instances, the prosecutorial arm doesn't oppose. And then there's a determination by a fact finder. In some instances, it's a court. In some instances, it's the Victim Compensation Board. And the determination is initially by a preponderance whether a crime was committed or if it was not committed.
So in a contested case, it could involve discovery, additional investigation, testimony of witnesses.
Yes.
All of the above.
All right.
Practice, does that happen?
Just and then the reason I'm asking is because I noticed, that attorney's fees. I imagine this is a very difficult thing to do without an attorney, and I noticed that attorney's fees is one of your proposed.
Right.
Yeah.
Tom, correct me if I'm wrong. I believe that there was data in the memo that said the number of people who exonerated themselves outside of court just by going through the Victims' Compensation Board is low. Can you refresh my memory on that?
Yes, and I think the Victim Compensation Board wouldn't say they're exonerating anyone if you haven't had a court determine it. But I think, and this is data from James and John, is I think since we've sort of set up this process where if a court says you're innocent and the compensation board has to pay you automatically, or there's a presumption they will pay you unless the attorney general or DA now objects to it, that's how everyone is getting successful compensation. I think there's maybe one person who actually went through the full, I'm showing for preponderance to the board for the first time and they're agreeing. So almost everyone who's successful is going through the court process. James and John, am I getting that right?
That's
Yeah.
right.
But now the board is also denying other people who are applying. So the board is still playing that role and having hearings. It's just the people who are actually winning are doing it outside of the board, essentially.
Right. If I may jump in real quickly, I mean, absolutely, yeah, he's absolutely right. But you still have those cases that are being contested of exonerated individuals at the Victims' Compensation Board. So yeah, just because you have the new ruling in the court, I mean, in the law that says that individuals that get that fact finding from that habeas or from that evidentiary hearing and where they're not contested, where you do still have people who's coming home through the other processes that are not getting that, and when they find themselves in front of the Victims' Compensation Board, again, the classification, I mean, again, my position is simply as this: the classification of the individuals, the innocent individuals, are coming home as being misclassified at the Victims Compensation Board by calling them wrongfully convicted and having them is exactly what you said, ma'am. They do have to go back to a little mini trial right there. And if unsuccessful, it becomes a thwart. And the fact of the matter is that the numbers in regards to the individuals who are being found factually innocent that are coming home as of now is not as large, is not that large. You have a larger portion of our population that are not getting compensated because they're coming home through these other processes.
Thank you, Mr. Anthony. That's helpful. And so I'm going to venture a guess that not many currently incarcerated people are seeking compensation or successfully obtaining compensation prior to a finding of exoneration or release from prison.
I believe you're asking about whether people who are currently incarcerated are seeking compensation?
Or could they possibly? I assume they don't, but maybe they do, and could they?
I believe they
the statute. Some statutes actually require that you not be incarcerated at the time of application. We could look into that particular thing. I'm not aware of anyone who's applied from as an incarcerated individual. And you know what we're wrestling here with, taking a step back, legislatures across the country have decided that they are willing to compensate, to see a distinction between legal innocence and factual innocence. Legal innocence is the overturning of a conviction, the removal of that. Factual innocence is something more. And every state that compensates, including California, requires that something more. And what that something more is the proof that the individual did not, as a matter of fact, commit the crime. That proof can happen and is increasingly happening at the same time as the release from prison. So we've had, for example, in California, in the last 5 exonerations, I believe, through the LA District Attorney's Office, those have been instances in which the convictions have been vacated, the charges have been dismissed, and a finding of factual innocence has been issued by the court, all in the same order, all on the same day. And at that moment, that person is appropriately immediately eligible for compensation, and it's merely some administrative time, too much time, but still some time. At least they don't have a fight. The challenge that every state faces is what happens when that finding of innocence on the record by a fact finder has not yet been made, because until states are willing to pay people without that, we're always going to run into that problem. So I think what we're looking for is, let's have a clear statute. Let's have a transparent, fast process, and give every applicant a fair opportunity to establish that they were inside for something they didn't do, and then pay them and provide them with services effectively, efficiently, and at the levels of no lower than any other state, and hopefully more generous. And thanks to Obi and Ignacio's work, we are more generous in some areas, but we're falling behind in many others. And finally, in order to get this done, we need a redraft, because what we have now, and what is so incredibly difficult to describe in just a few minutes, is the result of patchwork, tiny incremental fixes, trying to get around problems. That's why we have so many routes to compensation right now. It's time to select the best one, the cleanest one, and write a clean statute. And that's why it's so appropriate for this committee.
Thank you so much for that. I appreciate it.
Yeah, I
have a quick question.
Yeah, Professor Ochin.
I appreciate all the work that y'all are doing. It's good to see you again, Obi. I think we met last year. My question is, so looking at this sort of like a tort scheme, and looking at the injuries that folks have experienced as a result of wrongful convictions, obviously this is focusing on the individual rather than the true number of people who have been harmed by the wrongful conviction, which is their families, right? And so I'm wondering, are there any schemes that provide compensation or support not only to the incarcerated individual, but to, say, the children of the incarcerated individual who, if we're thinking about this in a tort sort of sense, have lost consortium with their loved one for a period of decades and have been, significantly harmed as a result. Those children might even be adults, right? So, right, there's a significant harm to those folks. So I'm wondering, is that a part of the conversation that we're having in California? And does any other scheme attend to the harms that the wrongfully convicted person's family has experienced during the time that they've been incarcerated.
So I can give an initial response. Thank you for that question. One of our proposals that we've seen in other states, but that California doesn't yet have, is paying, in addition to the award, paying child support arrears that occurred while the person was incarcerated, because that's certainly one of the direct economic effects, both on the other parent than the one who's incarcerated and on the children. And there are a couple of states where they carve that out of the award, which it's important to make sure that people have their child support, but we think it's more just to pay that in addition, because that wasn't something that person didn't have the option to work and pay. And so that's in our proposals. Regarding other things for family members, something that we've seen in some other jurisdictions is an extension of the academic awards, like Mr. Anthony was talking about with community college and that sort of thing, extending that to children or people that the exoneree is a guardian of, so that they have a right to that too, because that, certainly they missed out on someone having helped them along through school, having them helped to apply to schools, that sort of thing. And one last thing I'll say that we've seen in other states is making it explicit that in the event that an exoneree dies either before they're able to file a compensation claim or before their claim is completed, their heirs can either bring the suit or continue the suit. Now, our view is that in California, at least in the route through the courts, there would be an argument that existing rules on, when an heir can continue a case or bring a case might provide some support, but especially because we have these twin paths, and one of them is going through the Victim Compensation Board, which isn't a court. It's not entirely clear that those rules would apply, and so one avenue would be to make it explicit in the redraft of the statute what rights the heirs have to pursue the compensation.
And if I could just add one thing to that, you're asking, your question is a great one, because when we ask how we can make amends or how we can provide, what are we doing when we're providing compensation? And at one end of the spectrum would be an open prove up of all impacts, damages, etc. And that's not the chosen route for California so far, nor for all but one jurisdiction in America that chooses to have a statute. And instead there is typically a flat amount of money. And it's often untheorized in terms of whether it's what it's aimed at doing other than providing something. And so that's another area in which we struggle in trying to respond with integrity to the problem of wrongful conviction and wrongful incarceration, is that these remedies are limited in their scope, but also in their intent in some sense. And if you read the preambles, they're not talking about impacts on communities, impacts on families, even though they very well should do that.
Anthony, do you have something you want to add?
I wanted to add in real quick. That was a great question as far as the impact on family members. I just point out one of the reasons we keep getting distracted is Obi and I right now are in Sacramento at a 3-day retreat, intergenerational retreat with exonerees and family members. And so we just finished an emotional 2.5 hours talking and hearing from the exonerees and their family members about some of the struggles that they've had. So it's a great question. Thank you for raising that. And there isn't anything now. I'll also raise one other gap. While we've been successful in pushing legislation, one bill that we have struggled getting through has been, in addition to and separate from the daily compensation for wrongful incarceration, has been some funding set aside for mental health services for exonerees. That bill has died twice in Appropriations Committee. And I can tell you that the conversations with the Victims Comp Board have been extremely frustrating, because they keep saying it's just too hard to track. And that's why they keep throwing the cost up too high. They're like, well, how do we know? And how do we, they want to check the doctors, what if they go, all kinds of obstacles. At the end of the day, we've been successful in getting the housing, some basic services, some gate money for exonerees, where, none of this existed before in California. But we know that the mental health challenges, begin, behind the walls the second they're released and continue for a long period of time. And if we're not taking care of the mental health needs, that there's a problem. So I want to keep that in mind, that does not get lost in the discussion.
Sure, that's all super helpful. And I also want to just keep in mind also that all these damages, can be recovered upon, if there's a case of negligence on behalf of somebody who has, caused the wrongful conviction, maybe police, prosecutors, or whatnot. That's a whole separate issue that we're not really addressing at all. I had a question is, the current law is for wrongful convictions. Is there any consideration about wrongful incarceration? I'm talking about pretrial, mostly. Is there any way to get compensation if, let's say, you're exonerated or acquitted and then able to prove your innocence, but
Right.
you've been in jail for a year?
Conviction.
No,
So-
if I understand you correctly, because there's been a couple of individuals, not only one specifically here in the state of California, but also outside of the state of California, that goes towards something like that, where the individual get exonerated for a crime, but also suffers in there for a separate crime, but doesn't
No,
walk
I'm
out.
talking
Is that what you're saying?
about the same crime.
Okay, the same crime.
Yeah, if you're acquitted, right, but
Yeah.
you've been in jail for a year, can you recover any, and then you actually prove that you're actually innocent, somebody else,
You were incarcerated.
can you recover?
So the way that it's currently set up under Penal Code Section 851.8, there's a different standard for this, and this is a different standard that we're actually okay with remaining, and that's if arguably would apply to this. This is if you're arrested and charges are not filed, but it's sometimes been interpreted to extend to you're acquitted. That people have gone through this. If you can prove, basically the standard there is, well, why did they hold you in jail? They held you in jail because the court believed they had probable cause to hold you while you were there. If you can show that they actually didn't have probable cause to hold you, in other words, that you proven your innocence to the point where they didn't have probable cause to hold you, then you can get a court finding that you were innocent, and then you can take that to the VCB. It is not written to specifically apply to the acquittals. And so it would probably help to have that explicitly in there.
Yeah, so one thing, the pretrial detention should be part of compensated time. We would also advocate for not requiring imprisonment post-conviction in the instances where someone is given a suspended sentence, for example, but does time on parole, or I'm sorry, does time on the sex offender registry, that should be compensated. In other words, anything that arises from the conviction itself. I think you're asking, though, a different question, and which is what happens to the person who is arrested, charged, tried, and then and held, and then acquitted. Is that right? So that is
And then they're later able to prove that they're actually innocent without any negligence, they did have probable cause, like no bad actors, but you're actually innocent.
So that is not covered, I mean, in most states, in a way that is unfortunate and unfair, certainly to the people who have to go through that. They're told you're free to go, I believe, at the end, and that they bear the costs on their lives of all of those things. That's beyond the scope of what we've considered for this particular subject, since it's arising, what we're talking about is arising from a wrongful conviction, and all of it turns on a conviction. But I get calls all the time from people who say, hey, this happened to me. I was ultimately acquitted, or they dropped the charges before I went to trial. What is there for me? And our systemic response is unfortunately nothing.
And as far as you know, no state has addressed the problem.
As far as I know, no state provides compensation for the person whose charges are either dismissed before trial or acquitted after trial.
Right, and what I'm suggesting is that it's to be more the mere acquittal is sufficient to get compensation.
So, right, it would be the opening up of the process to allow the person to demonstrate factual innocence, right? And if so, they would be eligible for the compensation of some sort for the time they were held before, or conceivably something in addition, even if
The
they were
same
held.
compensation as anybody else who's wrongfully incarcerated.
So the statute could be expanded to provide that. I'm not aware of any statute that currently does that around the country that allows you to do that. The trigger is typically a conviction and incarceration time.
Other states compensate for probation and sex offender registry enrollment.
Yes.
Most
Yes.
other states, or most states do not.
Not most
Not
others.
most.
In the past, yeah, in the past 10 years, when new statutes have come online, most of them have.
Right.
Relatively new phenomenon.
Yeah, that's a worthy point. California is unique in the country where every single session there's been a bill trying to tweak these 6 statutes, right? In most states, that they take a run at the compensation statute much less frequently. And so I think it's important to note that when they are doing that, they're increasingly trying to provide that. And there's no justified explanation for why you wouldn't compensate for time wrongfully spent on parole or the sex offender registry probation. Albeit the way it's done typically is at a lower dollar amount. But that is a real burden and should not surprise anyone that it is, and we should be compensating for it.
Number is always difficult to come up with what that numbers. Does anybody else have any questions? All right, Mr. Eldon, Mr. Mink, Mr. Anthony, thank you all so much for your help and for your work. We will be in touch, I'm certain. Please do not hesitate to reach back to us if there are suggestions that you think that you might
If I could
further
just
suggestions.
just say one last thing. We hope that the committee and the spirit of this we should be looking for wrongful convictions. We should be trying to find them, create a fair system where people can get out faster, sooner, better. And when it comes to compensation, we should be looking for all the people who can prove that they were innocent. And part of a recommendation we haven't talked about today is a look back opportunity for many in the past who did not have a fair shot and should. And we should be in a remedial way, in a reparations fashion, looking to find people.
Are you referring to the cap on compensation that used to exist in California? What are you referring to?
I'm referring to both the cap. I'm referring to the time when the deadline was 6 months and people didn't know about it.
Okay, slow down. I just want to make sure that we understand what we're talking about, because these are
Absolutely.
important. All right, so
But
we haven't talked about it. There used to be a financial cap on the amount of reward that you can get, and that's one of the proposals that we've talked about in the memo. There was a 60. What was the deadline?
180.
180 days.
180 days to file a claim of wrongful conviction. Other lookbacks that you want to make sure that we get a hold of?
I think that it would be important to look back at. Well, I think I'd want a little more time to propose, and we can do a supplementary memo on what other lookbacks be appropriate. But again, my point was really more on the overall approach, that we should be trying to find the people who and making it possible for them to meet a fair standard through a transparent and clear process. And so few states are adopting that approach. We should be looking for the wrongful conviction, looking for the people who can prove that they were factually innocent, and compensating them promptly and generously.
No, I agree with that. And that's a decent transition. Thank you. That's a decent transition for our panel that we're going to do after a quick lunch break, which is, I think, the most important remedy for somebody who's wrongfully convicted is to make sure that they are released from custody to begin with. In some ways, we've taken this session just for scheduling purposes, sort of a little bit out of order. First, you have to get out of prison for the most part, and then you can get compensated after that. But in any event, thank you all. We're going to take a quick lunch break now. We'll resume at 1 o'clock. So let's just take half an hour for.
Well, we should come back at 1:30, I think, Mike. Our panelists won't be ready till 1:30 for the next panel.
I stand corrected. We'll come back at 1:30. I was trying to keep us ahead of schedule, but all right. So take an hour for lunch. See you everybody at 1:30. Thank you everybody in the audience, and we'll have one panel and further conversation about the recommendations for our staff. Thank you all very much. See
Thank
you
you.
at 1:30.
And thank you, guys.